go. And yes, we are live now. And thank you, Andrew, for taking out time and being with us. And it's always nice to meet you and listen to you. So please just introduce yourself, and it's your show. Like I've always keep telling people, this is that one opportunity where I don't say anything. I come in only when you ask me to come in. So please,
Okay.
Andrew.
Well, it's always a pleasure having you come in, Vikram, because you ask such good questions. So, good afternoon, good evening, good morning, wherever you are in the world listening to this. I am Andrew Miller. I recognize, I think, all of the faces who are in front of me today. I have known Vikram for quite some time now, probably over a year, and I'm in awe of the energy that he has to bring us all together, and what he is doing and what he has done for the mediation community, and I hope what the change that he's really going to make in India, which is crying out for mediation. So a little bit about myself, and I'm going to keep this to a minimum because it's not this isn't about me, but as I think most people know, I practice primarily now as a mediator. I also sit as an arbitrator, but it really is, the majority of my work is now as a mediator by far. I am a lawyer, a barrister by trade. I have been a barrister qualified for 32 years now. And I can see you're all looking at me. Yes, I was a child prodigy. I started when I was 10, but we'll leave that aside. I actually struggle with the 32 years. In a recent mediation, I use the phrase quite a lot, of English old money, pounds, shillings, and pence. And it's always good to sort of pay attention to your audience, because I realized that half if not more than half the people on the screen had absolutely no idea what I was talking about when I said pounds, shillings, and pence. And I then had to explain it. And I explained also that my 18-year-old, when I explained it to her, couldn't believe that I lived in the dark ages, or indeed that I was so old. But yeah, so I struggle that I have been a lawyer for that time. I was what the Americans would call a trial attorney. I was doing litigation. It was all commercial litigation. I never did any crime or any family. And my specialism around, obviously it was general commercial, but my specialism was around buildings, and it was construction, buildings going up and buildings falling down, property damage, fire, explosion, floods, and all the professional indemnity, professional negligence claims that came out of those, and a lot of insurance related work as well. And so my journey to mediation was quite a personal one, and in a sense was, I think, nothing to do with any culture or tradition in the UK to do with mediation. I was simply fortunate to see my first mediation in 1995. I was instructed at the time by an American firm. I was instructed in a construction case being led by a Queen's Counsel then. And it was a process that I was totally, utterly unfamiliar with. And I was in the vast majority. So that's back in 1995, some 25, 26 years ago. And when it was explained to me, it meant absolutely nothing, because the word mediation had never been said when I was at university. It had never been said when I was at bar school in 1988, 89. And it certainly wasn't talked about by those practitioners around me. So the in-house counsel, who happened to be American, might as well have been saying to me, talking about medication or meditation, for all I understood. But what I then saw was a process that was something very different from what I taught. And that set me on a journey of actually being someone who used, as a practitioner, who, having seen that at an early stage, then went ahead and used it a lot in my practice. And I always had some strong views about mediation. And they were, and this is relevant to actually what I'm going to discuss in terms of cultures and traditions. My strong views were supporting the mediation as a process, because I could see it worked. But I was not a strong supporter of mediators. And I found that of the mediators I saw, that the vast majority did not necessarily help the process. And it sort of explained to me as time went on why why the same mediators were used again and again for the type of cases I was doing. And having had this opinion, I sort of put in the end, my money where my mouth was. And I started dipping my toes into the mediation pond about 7 years ago. And thankfully, they got nibbled quite quickly. And I kept doing both, being a barrister and being a mediator, for the best part, I think, of 3 years. And then I finally decided, for many reasons, to jump ship. One of those reasons was actually I found, after doing 25 years plus of being adversarial, that I was actually enjoying the mediation more. And so it really was almost like, although I was doing the same subject matter, it was an eye-opener. It made me reflect an awful lot on how I'd been as a lawyer in the past. I realized I probably should have been a mediator before being a lawyer, probably would have been a better lawyer. But somewhere, and it wasn't just, somewhere along the way, and I mean before this, I had learned, and it took a good number of years to learn, that the best gift that any lawyer can give to their client is the gift of settlement. And I saw that. I didn't always practice that as a lawyer, but as a mediator, that's the, if I'm in an echo chamber, that's what I shout to the lawyers around me. So that's how I got there, and now I mediate. I mediate on a full-time basis, and COVID has actually resulted in my mediation practice sort of getting in even more busy than it was, and so I am mediating full-time, and there's rarely a week that goes by when I'm not mediating. So that's me. And when Vikram sort of told me about the title, I thought, that's interesting, because I've never thought in those terms about the UK. And I've given talks in the Middle East, I've given talks in Asia about mediation. And the one thing that I always talk about, and as Vikram knows, I've given talks in India, it is the fact that mediation has existed for hundreds, if not thousands of years in many parts of the world. And that's not the case for the UK. We don't have that tradition of the village elder, of someone going to the village elder to have something sorted out. So I started doing, for this talk, I started doing some research and thinking, well, maybe I've got it wrong. Maybe I just don't know the history. But everything I looked at seems to suggest that our background, if you went anywhere in India, Africa, lots of places in the Middle East, Asia, Southeast Asia, China, you will find this rich history of mediation of sorts. But you can't find it in the UK. And the best I found was that there were occasions when the church would step in Middle Ages and sort out disputes, but normally they were sorting out disputes for the local lord or for the king or queen. And that wasn't really in terms of mediation. It was more dictatorial and telling people what to do. So we just don't have that rich history, and I think that comes. It therefore explains why, having been through 18 years of school, 3 years of university, a year doing my bar exams and then a year of training in chambers, why no one had ever said the word mediation to me. It wasn't something that rolled off the tongue of anyone. And I think when I started looking, what's the reason for this? And the one thing that England, well, I'll refer to the United Kingdom as such, is an incredibly rich legal history. And as we know, the British Empire did some incredibly terrible things over its time. But one of the things that perhaps it did that may be said to be a positive, and the positive in many respects, was exporting its legal processes and its legal tradition. And it made sure it did that, not necessarily for good reason, but it certainly did that throughout the British Empire. And as we know, India is a common law system, a lot of Africa is a common law system, and indeed parts of Asia are a common law system as a result. And so we did that. And the legal history goes back hundreds of years. So I mean, you could trace it back to post-Battle of Hastings and the courts that were set up then, 1000 AD and etc. But I'd say, if I think about my studies, the legal system as we know it probably went back to the 18th century. It was rare that it was rare that we ever referred to an 18th century case when we were studying, but it happened. We certainly refer to 19th century cases quite frequently. So we were referring to cases at least 200 years old. And that system, effectively the same legal system, stayed in place for hundreds of years. And I think what that has meant, when going back to the title of culture and traditions, it is that there was, and there has been for so many years, an ability to deal with disputes, albeit that ability was via the legal system. And no thought, and it really is, because you really struggle to find anything past about 30 years, no thought seems to have been given to effectively changing the system or putting in place an alternative for tens, hundreds of years. And I think that where one change started to happen was probably in about the 70s but probably more in the 80s, when arbitration started to come into play. And at that time, I've tried to see whether arbitration was actually referred to as an alternative dispute resolution process. And I don't think it was, because the term ADR hadn't yet been thought up by anyone. So what was arbitration? Well, effectively, arbitrations of sorts had been used for a long time, especially in the maritime world. And it was the expansion of that into the commercial world. And I think it really, if you're looking as to, well, why was there an expansion back in the 80s in terms of arbitration, there was no thought at all that this would be useful to assist parties in litigation. What was the driving force of arbitration was that this was perhaps a good system for the solving of specialist commercial disputes, and maritime ones were sort of up front there. And so I don't think it was really seen as an alternative as we see it now. I read an article as to how once arbitration started to grow, then people started saying something that actually has proved not to be true, and that was that it was cheaper than litigation. And if you ask any or most people who work in commercial arbitration, they will say that is a complete misnomer, and arbitrations have proved to be incredibly expensive. But that was the sort of change that happened. But again, it wasn't really, as we refer to ADR now, it wasn't seen as such. It was something that grew up, and the commercial world started to use it. And I think what the UK, where does our culture and tradition for mediation really start, as we can't go back and we can't find that we were doing this thousands of years ago? It's quite simple that 30 plus years ago, it started taking off in the US. And essentially, there were people who saw that and decided that it was a good idea to copy it for the UK. And you can trace back really where it started, where mediation started to, I won't say take off, but started to have its own sort of entity. And that was about 1990. And that was when CEDA, which then, I mean, they gave us the full name at the time. It was the Council for Effective Dispute Resolution, was set up in 1990. And the individuals who set that up, in fact, it was Carl Mackey and Eileen Carroll, his wife, they weren't the only two, but they were certainly the backbone. And they very much had in mind the resolution of disputes by means other than court. And I don't think either of them would be offended if I said, I think at the time they weren't getting much attention, and it was a stalwart of not too many people. They had to create their own mediation accreditation, and CEDA, of course, still is one of the main accreditors, but they had to do that. So they had to train themselves and train mediators, and they got quite a following. But by the very fact that in 1995, 5 years later, the word mediation was still not being mentioned in any of my disputes, shows how slow it was. And what then happened, what was the next change for the UK, was in fact the Lord Chief Justice in the 90s, or a good part of the 90s, was someone called Lord Woolf. And Lord Woolf put together a paper. I'm hesitating, but I'm trying to remember the name. It was called Access to Justice. No? And he spent quite a bit of time, I think also visiting the States, but studying how the legal profession was working in the States and how it was working, actually, I think primarily in California, rather than somewhere else. And California had already taken mediation to heart. And what happened in terms of the access to justice was, it was the first judicial statement that suggested that there should be alternatives to litigation. Now, even some 30 odd years later, or 26 or whatever since that time, alternative dispute resolution has never been defined in the UK, so it was pretty nebulous in terms of what was being described. And what then happened was, and this was a major change to the legal procedure in England and Wales, and then the other jurisdictions followed. But what happened was that there was a complete change or a large change to the procedural rules, which took place in 1999. And that was the first time that the rules, the procedural rules, gave an indication or a statement that the parties should give thought to alternative dispute resolution mechanisms. Not that they had to do it, but they should give thought to it. And it also allowed, I have to say in quite a convoluted way, and not a straightforward way at the time, it allowed for the judges to penalize parties in terms of costs if they had not attempted ADR. And so that really was the beginning of it. And what if I jump forward now, and I'm sure many of you are familiar, that the buzz in England at the moment is talk about compulsory mediation. And it would seem, if you take it as a face value, that we've come a long way. And some people think, well, we're about to have compulsory mediation. Yeah? But the reality is, and this is my own personal view, the talk back in 1996 about access to justice and about making use of other procedures was driven at the time, not simply by the Lord Chief Justice, but by a government that wanted to spend less on the legal proceedings. And so it's very easy to see why it was better to cut down on the number of cases going through the court. And in a sense, the approach to mediation is still mirroring that sort of attitude, because the courts are overloaded at the moment with actually with small litigation. And it's the figure that the Justice Department has put out is 75% of cases are of a value of under £10,000. And that's why there is this talk now at the moment in terms of whether there should be compulsory mediation. That's what they are trying to deal with. So it's interesting. I'll come back to that. It's always interesting to see, well, what's this behind this? Is it really a love of mediation, a belief in mediation, or is there really something? Is there something else behind it? But what happened in the UK is that, going back to 1999, having the civil procedural rules, which allowed for this, we started to actually see some litigation happening in respect of mediation. Now, the civil procedure rules came into effect, I can't remember if they came into effect in 99 or 2000. And the first authority, and it's still quoted, it is Hasley Hall against Milton Keynes General Trust. And that was the first time the Court of Appeal, so it had taken 4 years post procedural rules change. It was the first time the Court of Appeal actually grappled with the issue as to whether a successful party should be refused all or part of their costs by reason of their refusal to attempt ADR. And in England, the general principle is the winning party gets their costs, albeit they may be assessed down or taxed down. And what the Court of Appeal held there was that an unreasonable refusal to participate in ADR was an unreasonable conduct of litigation. And you remember that's why I said it was somewhat convoluted in the rules as to, there was no rule that said if you refuse ADR, you'll be penalised in costs. So the Court of Appeal had to find, well, we know we can penalise costs if you conduct litigation unreasonably. So we have to make a finding that an unreasonable refusal to participate in ADR is an unreasonable conduct of litigation. And they said so. They said that it is a form of unreasonable conduct, and it may, a court may, not should or not would, but may respond by imposing cost sanctions. But they put a huge caveat there. And the huge caveat was that a departure from the normal cost order, i.e. cost following the event, was only justified if it could be shown that the successful party had acted unreasonably. So that meant that the party who had wanted to go to mediation, having lost and having been responsible to having been ordered to pay the winning party's costs, then had to prove that the winning party's refusal to go to ADR was unreasonable. And that was a tall test to get over. So that was in 2004, and we then had to wait effectively another 9 years before another major case came along, and that perhaps gives you a real insight into the fact, and that was in 2013. So that gives you an insight into how seriously or lack of any seriousness, if that's the way to put it, the legal profession was taking mediation, and indeed the judiciary, because we have CEDA formed, we have other institutions formed from 1990 going forward, and we've now got to 2013. That's only 7 years ago. And we then get the next major case. It took, it's not that there weren't any cases, but they were following on from previous authority. This was the new one. And the judge in this case, the PGF case, Lord Justice Briggs, I think it was, he actually was someone who's a big fan of mediation. I saw a talk of his where he admitted that he had never mediated a single case of his when he was at the commercial bar as a barrister. But he was a big fan, and there may be a reason why he's a big fan, because his wife happens to be one of the leading mediators in the UK. So that may explain his sudden, having never used mediation, it may explain it. And the issue in that case is, what should the response of the court be to a party who, when invited to take part in ADR, no, they never mentioned mediation. It was always mediation, but they always referred to it as ADR. So when invited to take part in ADR, didn't respond in any way. So no letter came back at all. So it was quite unique to this case in that sense, or to the facts of this case. And in that, what the Court of Appeal held then was that silence in the face of an invitation to participate in ADR was, as a general rule, so again, not always, but as a general rule, of itself unreasonable, regardless of even if the refusal to engage might have been justified by the identification of reasonable grounds. So effectively, what the Court of Appeal was saying was just your mere refusal is enough to find unreasonable conduct, and you can't get out of that by retrospectively saying, well, I did have grounds. Once you have just refused to engage, then that's enough. So what this then led to, of course, was a situation, and I actually I have a mediation tomorrow. There's 4 parties involved, and the bit I was going to tell you has arisen here all these 8 years later. One of the parties last year refused to go to mediation, and what they did is what all lawyers were doing when they didn't, or their clients didn't want to go to mediation. They put down grounds. So in that case, in the PGF case, it was because when they were asked by the other side, let's go to mediation, let's mediate, they simply didn't respond. They ignored the letters, and they ignored 2, I can't remember how many, 2 or 3 letters. Yeah. So what happened from then is parties not wanting to litigate, or, and I stress this, or lawyers not wanting to, not wanting to go to mediation, or lawyers not wanting their parties to go to, their clients to go to mediation, would then put down very, very detailed reasons as to why mediation will not succeed. And that again made it difficult for the court then to find unreasonable behavior, because it's very difficult to unpick that sort of thing. So then what happened, the case that I think is an important case, it doesn't get as much attention as I think it should. And cases have now followed it. It is a case of Thacker against Patel. And that was a relatively low value landlord and tenant dilapidation case. And that case was, I think it was about 200,000 in the beginning. And what was different about this case was, this was one of those cases that should have settled a long, long time ago. It went to a trial, and it went to a 7-day trial. It was even worse because it was a 3 or 4 day, then it was adjourned, then there was another 3 days. The end result was that there was a claim a claim for dilapidations and another claim for damages that in effect the claimant won £40,000, and the I'm giving estimates of figures, but it was about this, and the defendant counterclaim got about £20,000. So the claimant ended up with only £20,000. Joint costs were well in excess of £250,000. Yeah. And the party that actually had been refusing to go to mediation, or not refusing, but finding excuses not to and dragging their feet the whole time, was the defendant. And they were penalized in costs. So it went to the Court of Appeal, and it went to Court of Appeal on the basis of the finding that the judge made. And he made the judge at that first instance, and the reason he penalized the defendants in costs and put cost sanctions against them, was that he made a finding of fact that if there had been a mediation, there would effectively, on a balance of probabilities, have been a settlement. And the words were used that there was a real chance of achieving a settlement. Now, if you think about that, that was a very bold move, because as a judge, you make finding of facts on evidence. And make a finding of fact on something that never happened is quite a difficult thing. So the defendants thought they were onto a winner here and went to the Court of Appeal, but the Court of Appeal actually said, no, that was a legitimate finding of fact. And the Court of Appeal said it was a legitimate finding of fact because the dispute was commercial. It was only about money. The costs of the litigation were vastly in excess of the sums in issue. Bilateral negotiations between solicitors, lawyers had not been successful. And so what was said was, by Lord Justice Jackson, was any mediator, and excuse any sexism that he put into this, I'm just reading it verbatim, any mediator would have had both parties in the room with him. He would have let them have their say. He would have pointed out A, the small gap between the respective positions, and B, the huge future cost of litigation. In those circumstances, I would be astonished if a skilled mediator failed to bring the parties to a sensible settlement. So leaving aside that he's only referred to one gender, that essentially set the scene for judges to have more confidence, and they are now. So you get, I would say, a few cases a year now where parties are being quite severely penalized if they have not gone to mediation. Of course, they can go to mediation and they can sit there the whole mediation with their arms like this and do absolutely nothing, going through it. And that's why people sometimes refer to it as being a tick box. So it's helped, but that gives you an idea of the background, where we've got to, and where we've got to. That's 2000. That last case was 2019, and another similar one to that was 2019. That's what's happened. That the judiciary, and the way I like to describe it is, what the judiciary started was with, I would say, encouragement. So the change of the rules was an encouragement to use ADR, and ADR almost always, I mean, it meant mediation. Yeah. And where we've moved to in my jurisdiction is it's moved, I'd say, from an encouragement to an expectation. So it's gone from being the carrot to being the stick, and the stick can be beaten quite hard at the end if a party doesn't comply. Now, that's all well and good if one party is very keen to go to mediation, but the other isn't. But we still have a situation where there are many examples where both parties to a litigation have absolutely no interest in going to mediation. And there's no penalty that can be applied to them, because no complaint is ever going to be put by one side or the other. But I think what has filtered through enough is an understanding that it's a bit more than an encouragement. It's an expectation. But if thinking about sort of culture and traditions, and on the one hand, the UK is a great user of mediation. We certainly have a lot of mediators, or we have a lot of people, I should say, who've been accredited. But mediation still has a long way to go in the UK in terms of numbers and for it being used throughout. I mean, I only do commercial litigation, so I can only really talk about that. And the family division has its own history with mediation, etc. But it still does have a long way to go. And it is still the case that in reality, quite a small fraction of cases are mediated. Now, that does not mean that the rest are going to trial, because as we know, in most jurisdictions around the world, the majority of cases that start settle before they go to trial, and that hasn't changed. And I think what's the bit that is the real rub and difficulty is those cases that don't go to mediation and don't go to trial, that settle, often go a very long way and incur substantial costs. And where the balance needs to change in the UK is those cases that are going to settle anyway should be getting to mediation sooner than running their course and settling 2 weeks before trial. And that's the challenge. It's the challenge to pick up the majority. What we hear about when we talk about mediation is actually the minority of cases. And there are lots of influences to this. So I think what's going back where I started, if I may, what's behind all this, and why has it been? When I speak, and I've attended talks by American and spoken to lots of American colleagues along the way, and there seems to me to be quite a distinction between how they embraced mediation as another tool in their toolkit, whereas in England it's been treated with a lot of reservation for the last 30 years, a lot of fear. We all know ADR means to a lot of lawyers acute drop in revenue. So it's a different attitude that's been applied, and I think it comes down to looking at what's the background. 30 years is nothing, absolutely nothing, if we're talking about mediation having come to the UK, compared with hundreds of years of traditional litigation. And as I said, we exported much of our litigation to large parts of the world. We have a legal history going back hundreds of years, a thriving legal system that has existed and exists very much in the same form. That's the thing. And so it's meant that it's the method, as I said, by which disputes have been settled. There have been offshoots. We've had the arbitration. There's been, and that took off in the 70s, 80s, and it is huge now. We know it's huge all around the world, especially in India. In the UK, we've had the creation of compulsory adjudication for construction disputes, domestic construction disputes. We've had dispute resolution boards. We've had the introduction of regulatory bodies who will determine professional and disciplinary matters outside of the courts. We've had the employment issues being taken away from the courts and put into separate tribunals. There's lots of conciliation schemes for consumers. So, for example, in travel, if your travel company lets you down, you can go to a conciliation scheme to deal with that. We have tribunals for everything. So if I park my car in the wrong place and get a parking ticket, I can go to a parking tribunal now. So not everything goes through the court. But what all we have actually thinking about, we have ombudsmen, so financial services issues go to an ombudsman, insurance issues go to ombudsman. I'm sure there are many others. But what we see with all of these is one absolute common theme. And that is all these mechanisms, although they may not be in the court, they are all a determinative mechanism. And what I mean by that is that it means that whatever the system is, whether it's the parking, or whether it's the adjudication, the dispute is being determined by someone. They're giving an answer, and the person giving that answer is not the party to the dispute. They're putting submissions in, etc., but they are not part of the resolution process. And so it's this determinative process that has been, I think, the guiding force and the backbone to everything that happens in terms of disputes in the UK. And for me personally, explains why mediation hasn't grown as perhaps one might expect it would have done in the commercial world. Why perhaps it's not accepted, because the norm is to have someone tell you what the answer is. And why perhaps, why perhaps it's feared, because it doesn't fit in with what is the norm. No. So all these different mechanisms are, of course, the antithesis of what mediation is itself, being self resolution. Yeah. So there's no natural background for it for people, and that's why it's. I wouldn't say in the UK it's in its infancy; it's gone past it, but it hasn't necessarily matured. And what I think is, and are really what are the issues? If I can, having set the scene for where we've got to in terms of culture, what do I think are the primary issues in our jurisdiction, in my culture going forward? The first is still the lack of knowledge about mediation by the general public. I am always, I think probably the more I do, the less surprised I am, but I'm still surprised that I can sit there in a mediation. I can have the CEO of a major corporation in front of me and find out, or if it's not the CEO, the head of commercial, head of whatever, and find out that despite having dealt with umpteen disputes over the last 30 years, this is the first mediation they've been involved in. That's a regular feature. I did one involving telecommunications, the setting up of the 5G, and at the end of the mediation, the commercial person turned to the legal person and said, you may have seen, I haven't taken part in the mediation. I've spent the whole time working out how much we've spent on these projects. And they were digging the trenches, putting the masts up all over the UK. And he said, we've spent 3.2 million in legal fees over the last year and a half on these. And he said, in this case, and it was a case, the claim was for 700,000, mediation we settled at about 500,000, including costs. And he said the costs of this mediation was 50,000, and we reduced an invoice that was originally for 700,000 to 450. And he looked up from his laptop and said, why have you never mentioned the word mediation to me before? And that was one of the big telecom companies. And it really begs the question, but it comes down to a lack of knowledge. The training we have, and this is why, having been out and taken part in the Indian mediation competitions, etc., I'm in awe of what's going on in India. The training on mediation it is still pretty minimal in the UK universities, etc. But the public doesn't know. It's easy, you know, to people are going on about the Lord Chief Justice did this speech, did that speech, he said this. That's all keeps coming up on my, you know, my LinkedIn feed, etc. But those who are one step away from me and not doing law are not getting that feed. There's nothing they're learning about mediation. Lawyers, it may be pinging in my LinkedIn or my Twitter, but it's not pinging in there. So there's a lack of knowledge. Is the first thing. I think then, and I've talked about this before, and it comes down to what I've mentioned about ADR, acute drop in revenue. Lawyers have to buy into mediation, and many have in the UK, but many haven't. That is a problem. As I said, I remember working with an American, and it was about, I think it was 2000, 2001. He was the only American in the room. There were lots of British lawyers or English lawyers, and at one we were going into a mediation, and he made this comment: "You Brits just do not understand mediation." And he made that whole speech that I said the part of a bit. So, you know, when it came to the States, we embraced it as an additional, you know, feather in our cap or string to our bow, and you almost see it as the enemy, instead of seeing of what you can do. And I think a lot of it is attitude. And where I started, where I think, and I put my hands up, a mirror to myself. You know, I was as bad as everyone else. As a lawyer, it's very easy to forget that actually it's not your case. You don't know everything about the client's business, and you don't necessarily know what's best for the client. And some lawyers will find that quite strange to hear. And I think that's something that's not taught, and it's something that has to be, you know, that has to be learned. And that's the issue. So you've got the individual attitude of lawyers, and that shines out to me. I mean, I've now become, I think, good enough to see very quickly to identify, you know, are you mediation friendly or not? And I think the biggest tell in a mediation is when I have the clients and I do a preliminary meeting and I say, you know, I'm explaining to them about mediation, and I'm telling them a lot of stuff that's new. What has the lawyer been doing with their client before? And I don't mean in the minutes before I come in. I mean in the weeks before. I mean in the years before. That this is, and they'll say, "Oh no, it's really new. We don't know anything about it at all. We don't know what to expect." Yeah. And there is a principle, because if you read the rules in I think more than a certain way, there is an obligation on lawyers and our jurisdiction is narrowed down, so let's say in the world, to actually tell your clients about the alternative to litigation, and that's not happening. So that you know, there are some, you know, very good. There will be some lawyers who say, "Forget this. We've got to go to mediation as soon as we can." But it's this lack of knowledge, and it's coming from mediators. That some from lawyers. Some lawyers respect it. Some you know, some don't. But that has its thing. We have no regulation in any of the UK in terms of mediators, etc. And I think that presents its own problem in terms of respect for mediation and mediation professionals. And I was listening this morning to the mediation breakfast club, and the speaker was actually David talking about, I've forgotten his name, Chuck. He now lives in Berlin, but he was talking about the mediation in Israel as it happened. I can't remember his last name, but I was very interested to hear that in order to be a court-appointed mediator, you had to have a certain amount of training, a certain amount of time spent, observations, taking part, etc., and you had to do examination. Now, we have none of that, and what we have, and this is why having said, look, the lawyers, you really need to do more, the mediation profession in the UK has really given itself an own goal over and over again, because it has set up to be a mediator, or to call yourself a mediator. You don't have to do anything, but it is a 3 to 5 day course, an accreditation course that no one has spent a great deal of time looking at. The CMC holds them out of these regulated mediators. They have no statutory basis whatsoever, no regulatory basis. And they give out their kite mark to basically anyone who sets up a mediation school. And many of them are not very good. So you actually have a system in the UK where mediators are, I mean, I hesitate to say that, because I was going to say mediators are being churned out, but you have people with accreditation being churned out. And the big complaint is we now have 14, 15, 18,000 mediators in the UK, but only 500 have work. And the mediation profession really needs to look at itself and say, I could not just write to my university and say, can I come and do my law degree? I had to take exams and get accepted. I couldn't do the same for my bar degree. I couldn't do the same for my chambers. I had to prove myself. And there really needs to be a pause where we say, well, how is it we want to have this profession that goes alongside the legal profession, that is a real alternative to it, not just an adjunct because people, they have to do it so they're not penalizing costs. What do we have to do? And the simple thing is we have to become more professional about it. And we have to make it that it actually means something when you stand up and say you're a mediator. In the same way it means something when you've done a law degree, when you've done your professional examinations. And I think that's the profession needs to sort of look at it itself in that. Because at the moment, what we have, and this is, I'll sort of wrap it up with this, and this is a talk I give, so I'm just going to give a where we are in terms of our culture and our tradition is the relationship between mediation and litigation and arbitration. I include it in that. Yeah. And you can only be an ADR, an alternative dispute resolution process, if you are an alternative. And mediation in the UK is not really an alternative. It's an adjunct. It's an add-on to litigation. Because in most cases, the disputes that get to mediation, and I can only talk about in my commercial world, they are already in litigation. And they may not even, most of them are already in litigation. Litigation has started, they're a long way down the road. The mediation I got tomorrow, the actual event, and it's a product liability and property damage case with a 9 million value. The event was in 2012. The litigation started in just before limitation ended in 2018, and trial is taking place at the end of January. And finally, they've got to litigation. Finally, they've got to mediation at 3 to 4 months before trial. No one can say that mediation tomorrow is an alternative dispute resolution process. It's an add-on to the litigation. Hopefully, we'll achieve a settlement, but it's a settlement that comes when costs are already in the litigation. You can imagine what costs are with 4 parties. They're in their millions. And so until we have a situation where we move, and I know this would be an Americanism, move from I'll see you in court to I'll see you in mediation, we're always going to be an adjunct. And that's what's got to happen. There's got to be this idea that not every dispute has to go, not every dispute has to be taken to lawyers, be started on some sort of litigation process, and whether it actually starts in the courts or not, and only then gets to mediation. There has to be an attitude, and it has to come from the lawyers, because they're the ones, I call the lawyers the gatekeepers to mediation. It has to be them saying to their clients, this is what is needed. In this case, forget, I can put you in trial, you can be in it for the next 2, 3, 4, 5 years, but let's try mediation now. And let's get the other side around a table, because the earlier you get there, the earlier you talk about the dispute. The mediation tomorrow is going to be about costs. Everyone now understands the dispute, but costs, if it goes all the way to trial, costs are in excess of the value. The 4 parties' costs are in excess of the value. So that's what it should be. So the talk of where does compulsory mediation fit into this, and that's a paper has gone out from the government, or I'm not sure what you call it, but it's a questionnaire. It's got something like 30 questions on it, and it's asking for views. It's sort of saying what some senior judges researched at a legal point as to whether compulsory mediation was a breach of the Human Rights Act, and they found that it was not. So that's the starting point for this. So they want to know what everyone thinks about compulsory mediation. As I said, when one drills down, one sees what's behind this. They want to find a way to get rid of these small cases. And there's 2 things that are coming out of this that people are holding their hands in horror. One of them, one thing is that the questions, and it's 30 plus questions, are written by someone who doesn't even know what litigation is, let alone mediation, but because they're so far off the mark, they don't make sense. But the other is there seems to be an indication, there wouldn't really be any need to pay for mediation. The mediators would do it for free. And so I actually think this is, I'd like to see what happens with this. I'm sure it's going to be like so many things that have happened throughout my career. It's not really going to go anywhere, because it's not being driven by what's best for those in a dispute. It's being driven by commercial concerns more than anything else. And that's the difficulty with it. And I said I'd finish, but I will finish on one point. And that's really where I'm seeing a change in terms of the commercial world. And it's a strange thing in a sense. So much bad has come out of the pandemic. But the one good thing, or I'm sure that there's more than one good thing, but a good thing that's come out is a greater use of mediation in the commercial world. And it's very simple why that has happened. And I can sum it up by actually real life thing that happened. It was about a year ago. I had a mediation. It was a solicitor I know. I've known him for years, and I know he's not a big fan of mediation. So we did the mediation. It settled on the day. And we were having a chat afterwards as they were drawing up the settlement agreement. And I said to him, what brought you here? You rarely use mediation. And he said to me, yeah, you're absolutely right. I don't like mediation. The settlement is an indication as to why I don't like mediation. That case is now gone from me. And I said, so why are you here? And he said, well, it wasn't my choice, it was the client's. And he said, what has happened is clients have been calling us up and saying, when's my court hearing? And we've had to say, we don't know, because the courts are in disarray, or we can't tell you if it's this year or next year. And clients have said, well, you've got to do something else then. And we've had to tell them, using the same line as I used before, that there is this thing called medication or meditation or something like that. I'll look up what it is and we'll see if we can do it. And so the increased use of mediation has been client driven. And again, the type of work I do where it's really been client driven is in construction cases where they weren't using it before. And so that comes back really to the bit I was saying. Settlement is a no-brainer. In the commercial world, bringing your dispute to an end as opposed to fighting your dispute and writing checks to your lawyers, is a no-brainer. And you really struggle to find any CEO, CFO and say to them, would you prefer to be in dispute or not? And they would say, I prefer to be, prefer not to have this dispute. I prefer not to see my lawyers. And so it's education, and that's the key. So COVID has caused a situation where lawyers have had to say to their clients, yeah, there is something else we can do. And then they find out that they can organize it within 2 weeks. And they're blown away. So it's a small snowball at the moment, but I think it will gain ground. I remain a massive fan of face-to-face mediation. I think half my mediations are face-to-face now. Half are still remote. Tomorrow is completely remote. Some are hybrid. But what the remote, although I am a fan of the face-to-face, lawyers are able to say, I can organize this for you quite quickly, especially if it's remote. So it's changed that. And I think that's what's moved forward. But I found, I did a lot of insurance work, and the insurance industry changed about 20 years ago in terms of their attitude to litigation, etc. And we all had to change. No lawyer went to insurers and said, I think you should change, you should save more money by doing this or this. The insurers had a complete change of how they operated and how they viewed litigation and their risk analysis, etc. And they told the lawyers, this is how it's going to have to work. So it has to be client driven. And when I haven't given a talk face to face for a long time, but I like doing it. I've done it on the webinar, but I have a slide that has reasons why people do or don't go to mediation. I have a whole list, as I said, the lawyer attitude, etc., workload. And the last one I have is the client. And I ask the audience, what's wrong with this slide? And very rarely anyone gets the right answer. And my right answer is that last line is in the wrong place. The client should be at the top. That should be the reason. Yeah. And I think that it's this combination. It's not one thing. It's the education. It's lawyers being a greater gateway, but the mediation profession has to take a good look at themselves. And it's not enough to simply say we're going to have these accreditations everywhere and have people holding themselves up, but have no regulation on it whatsoever, because it's got to be respected. The act of the mediator has to have the same respect as the lawyers. But I think what we do have is in what I've seen in the last. I've been as a mediator, mediating the last 7 years, and I've seen more change, I'd say, in the last 3 to 4 years than in mediation than I've seen in my whole 30 years of practice. So I think things are happening. A lot of it is to do with what's happening in the UK, but also internationally. And there is a huge appetite, and all this can only help. The more the more we can tell industry, businesses, etc., about it, the greater use there's going to be. So that's my limited view, and I caveat it with that they really are my personal opinions as to where we are, etc. So thank you very much for listening. I will look on in horror when you put this on YouTube, and you see just how you sounded.
Perfect, Andrew. Thanks a lot. Always a pleasure listening to you. But there are going to be questions, so please.
There are, but I cannot stay more than a few minutes. David will understand. David will understand why. Tomorrow is an important day in the Jewish calendar. I'm the cook in the house, and I have to get the food on the table by a certain time today. So I'm going to have to be leaving you very, very quickly.
I should have checked this earlier. I would have stopped you much earlier. Because the thing is, the things that you brought out need to be maybe questioned also, discussed also, because it is very important. I mean, you are an important part of the mediation world, and what you say and what people take from what you say is important. And I don't want people to take only half of it, and we should discuss it before it goes out, because if it doesn't go out without those clarifications and those discussions, I think people pick up the wrong thing. So, but one thing, let me start with this. But Jonathan, in his presentation, he's here, had spoken about some history in the UK. So maybe you can watch his presentation. So he got some reference, not that there is too much reference, but he got some reference, and he had spoken that out. So have a look at that. And the other thing is, look, there are two parts of it. One, you talk about the client on top. The other, you look at the US model, where it is, if you have a look at the statistics, 100 million cases are filed in courts every year. They are a 300 million population. Mediation for the last 45 years. The lawyers have controlled it. That is why that lawyer tells you that you have not understood it. It's big business. And how does it work? It goes into the court system. The mediator gets $40 an hour. The lawyers make their fees as mediation advocates. They are very happy. The justice system, the courts are funding the disputes of the clients by $40 an hour. I mean, come off it. Who gets that kind of money in the US? For that, to you saying they should be the professionals, they should have all the knowledge and the certifications and the best of it. But the self-interest of the courts is the backlog. They are not being able to deliver justice. I keep saying the justice is denied. Let me look at India. Justice is denied. 14 years, 20 years for a matter to be in court, you have denied justice. So put a board outside the court, say, we deny justice. Justice delayed is justice denied. Enter at your own risk of money, time, and peace of mind. So for them to even talk about mediation, which is a diametrically opposite method of dispute resolution, I think that whole colonial aspect, that's why I'll come to you, because today you are Mr. UK. Anything said to you is being said to the colonizer. The fact is that the fact that the courts have to be involved in dispute resolution, that concept has to go away from people's mind. The whole David, what he spoke about, and there are other people who spoken about this, that dispute resolution, there is a whole traditional method of it happening. The courts have a certain kind of a role that has been created for them. That role is what they have to be able to do. They can't do it. They want to send you to a totally different method of dispute resolution. And I keep giving this example. I'll repeat it to you also, because you are a person whose videos will be watched a lot. So let me put it out here also, Andrew. If someone goes to the government and requisitions the government to make a road to connect their village, it is the job of the government to do certain things in a country. The government tells those villagers, no, you must make the road yourself. Not telling them, obviously, they don't have the resources or they can't find time, whatever it is. No, not that. You must make it yourself. If you do not make it yourself, we will penalize you. So the kind of work that the court was supposed to do, the fact that dispensation of justice has to happen in a certain time frame also. And in the Indian context, again, Andrew, I'll repeat it because I have repeated it today earlier. Also, I'll repeat it again right now. In the Indian context, there are people lying in jails for more time than if they were convicted on first day. Can you imagine that? So in that kind of a situation, a judge is sitting in a courtroom and counseling parties in a divorce case that why don't you go for mediation, or you have to go for mediation. Today, there is a high court judgment. She says you have to, even if you don't want to. We have to say, we will send you there, whatever. Are you spending time for these things? Well, that guy, you have taken away his basic right of freedom. He's lying in that jail, even for a 1 day. I mean, whoever, say Andrew, you or that judge or anyone, for 1 day also, if I put you into jail, you are innocent and I can't give you a hearing because I'm busy talking to someone about whether their divorce should be through mediation or otherwise. I think they have got the concept wrong. And once they get the concept wrong, everything else that follows from there, all these absurd concepts, so the way mandatory mediation, they'll keep trying to bring in through judgments or law, they'll always, the foundation is the wrong foundation because they're not supposed to be part of it. It is a different method a person has come for. You want to do counseling, set up counseling centers for dispute resolution. There can be call centers. There can be people sitting there who can explain to them what the whole process entails. Damn good. Do it. It's already outside. But the moment the person walks into a courtroom in whatever way, he's come for a certain method of dispute resolution. Good or bad, if it's bad, close down those courts. If not a good system, don't do it. But if he's come for some, you're a service provider. You've come for a certain service. Can you tell the person, no, because I can't give you the whatever you need, I will force you to do something else. I force you to do some other service. It's like the post office. I go to post a letter. They don't have enough staff or whatever. They tell me, no, you must email it. You have to, we will force you to email it. I mean, come off it. You are put up for a certain thing to do, and to run away from that, you are going to find various ways to go about taking it through different routes. There is lots to I will go through, and I'm going to. I know you're short of time, but
I'm out of time.
I know that
Vikram, I'm sorry.
there's
I
so
am
much
happy
more.
to
There is
take.
so much more.
No, no, I know there is, and I'm happy to take part in another one. And I
Give me
should see
give me 2 minutes
what
more. What I'll tell you. Are you I talked about the construction industry, and you are part of the RICS, that whole concept of the Royal Institute of Chartered Surveyors. Let me tell you, I think the way the whole concept of mediation has been gone about. I did a little webinar on promotion and developing the culture of mediation, and there were people who were basically the RICS guys from this person from Mauritius had organized it, and I spoke about the concept of mediation and the culture of mediation. And this one particular person from that webinar actually went to his site and actually did it himself. A nice informal way, he did it everything, and he got a successful settlement there. So it's just, I think we're getting too focused and too lost in these, like you said, on the accreditations and certificates. Not the right people are not doing it, and the right people don't need any qualifications or certifications. They have all the experience, they know how to do it, and the right people will be picked up by people. People can decide whom they trust. You are not going to tell them whom they have to trust. I mean, why are we wanting to control dispute resolution? Let it go. You have not done a good job in terms of how you've pushed the court system around the world. Please let the dispute resolution happen in other ways. Everything is not the court system and lawyers. I know I mean, I maybe a little too much I've said here, but I had to tell you because you picked up so many
so
points.
sorry, but I'm going to have to go. Your wrath is less than those sitting at home.
Okay, no,
I will say namaste. Good David, Jonathan, and everyone else.
And thanks a lot, Andrew.
It's been a pleasure.